Authors generally receive copyright protection for their original works. However, if works are made for hire, the hiring party holds the copyright. In Marvel Characters vs. Kirby, the court faced an issue of superhero proportions when Marvel and a comic book artist's heirs fought over the rights to the artist's drawings. Jack Kirby was an influential and prolific freelance comic book artist who worked for more than 5 decades and frequently created works for Marvel Comics, including for Captain America and the Fantastic Four. Between 1958 and 1963, Kirby wasn't a formal employee of Marvel with a salary or benefits, but was closely affiliated with the company. He was paid a per-page rate for his work. Marvel could reject Kirby's drawings or ask Kirby to redraft them. Stan Lee, who effectively directed Marvel at the time, considered Kirby his best artist and consistently assigned Kirby work. Kirby worked with Lee for many years. Lee used the Marvel method, where Lee would meet with artists to outline the plot for new issues, the artists would come up with drawings, and then a writer would insert dialogue and captions. Lee allowed Kirby more freedom with the process than any other artists had. Lee gave Kirby rough frameworks and allowed Kirby to contribute characters and plot ideas. Kirby passed away in 1994. He had 4 kids. In 2009, Kirby's kids served Marvel termination notices, exercising statutory termination rights under the Copyright Act for 262 of Kirby's works that Marvel had published. Marvel sued, seeking a declaration that Kirby's children had no termination rights because Kirby's works were made for hire. Kirby's children counterclaimed, seeking a declaration the notices were valid. After discovery, both parties moved for summary judgment. Marvel's motion was granted. The court determined the works were made for hire and the notices were ineffective. Kirby's children appealed.